Down at Florida State, we now have a decision from Major B. Harding, who's a former Supreme Court justice in Florida, on the Jameis Winston Florida State Code of Conduct hearing. And Jameis Winston has been cleared. And we are pleased and privileged, and we say thank you to Jameis's attorney, David Cornwell, who jumps aboard and joins us. And I want to spend the time with him, so let's just get right to it, and then we can set it up and do all that stuff later. David, thank you very much for jumping aboard.
It's my pleasure. Good morning. How are you?
Good. Let me start right here. I read this decision, and just in full disclosure, I'm a lawyer. I practiced for over a decade, and I've done a bunch of this, not as much as you, but I at least have a working knowledge. I read this thing, and it says to me that Major Harding said, I don't find him more credible. I don't find her more credible. She has to have a burden of proof of being more credible, and she's not, so I'm sending everybody home. Do you agree with that reading, or did you read it differently?
It's clear that that's precisely what he wrote. I don't find one story more persuasive than the other. She had the burden of showing by at the minimum 51%. I'm not surprised because she adjusted her story for the seventh time and moved the alleged rape out of the bedroom where one of the teammates testified that it appeared to be consensual, and into a bathroom where nobody else was present or claimed to observe the act. This was the seventh change in her story. And in a he said, she said case, the best the accused can hope for is, 50-50, right?
So is when you say she's changed her story 7 times, is the single biggest change in her story that you would, if you were educating someone who didn't have the knowledge of the facts, that she changes her account of the location of where she claims the alleged attack occurred? Am I understanding that correctly?
Unfortunately, no. There are numerous other areas where she's changed her story. Frankly, you know what? There are no winners in this, and I feel sorry for this young lady. I think that she was abused by her lawyers. To walk her into this hearing room and say that she suffered from a traumatic memory loss without offering any evidence of a physical or mental exam, let alone any expert to suggest that there is such a trauma that enables you to have a better memory 2 years after an event than you do 20 hours after it. Now, I think in many respects, Justice Harding was charitable. Our brief lays out in painstaking detail the number of times that she was apparently coached to change her story. So, as I say, I don't think there are any winners in this. I feel sorry for this young lady to the extent that she was taken through the ringers in a process that was inevitable once she was coached to lie. Her aunt demanded $7 million from us. I mean, what was this about? What was this about? Why did they think it was okay to do this to a 20-year-old college student, to Antonor and Loretta's son? Because he played football? That's why they thought it was okay to do this?
Do you think it's over now? I mean, she has the right to appeal, or she could obviously file a civil suit at some point in time. Do you think this is over, or do you think Jameis is still going to have to continue on through this process, either through Florida State, through an appeal, or through a civil suit?
EK, I'm going to tell you something. I'm done guessing. I'm done predicting. You know what I mean? You because of your background as a lawyer, at the water cooler, you can flip coins and take guesses, but when you put on your lawyering hat, your job is to confront the problem that you're presented with. Mm-hmm. So I'm just going to deal with things as they arrive. But I will tell you this: these two lawyers that appeared on the scene after we rejected the $7 million demand, they're not lawyers; they're investors. They're plaintiffs' bar. They invested in this case, and I wouldn't be surprised if they tricked themselves into thinking that the return of their investment comes with the filing of a civil complaint. I'll tell you, with the filing of a civil complaint comes a counterclaim against this young lady, unfortunately, not out of anger, but out of necessity, and comes a new complaint against these lawyers because they made statements that are not protected by the litigation privilege and viciously attacking a 20-year-old college student, and we're going to go to their pockets to get damages for that.
So are you saying that if she sues you, you will counterclaim against her and her attorneys, or are you going to do that anyway?
No, we have no intention of doing it anyway. But of course, and you can explain it to your listeners when our call is done, there's not a chance we're going into a courtroom without counterclaims. Okay, right? Mm-hmm. But separate and apart, what I'm telling you is if she sues us, we'll start a new lawsuit against Mr. Clune and Ms. Carroll.
Florida State's Jameis Winston has been cleared in the Code of Conduct hearing at Florida State. His attorney is David Cornwell, and my guest here on the Erik Kuselias Show on NBC Sports Radio. One thing I noticed, I saw a quote in USA Today Sports from opposing counsel that says the 3 football players, including Jameis Winston, all refuse to testify and answer questions, and somehow Jameis Winston still wins. The order doesn't even follow the student code and ignores the bulk of evidence. Is that just a lie? Did Jameis not answer? Did he refuse to testify and answer questions?
This is why the time has come for the media to reject this vulture, to reject this fraud. I could release the transcript today and prove that he's lying. I could prove today that he's lying if I released the transcript. And he has lied throughout this process, primarily to the insider, in quotes, Schlabach at ESPN, who covered this story as if he was a personal PR flack for John Clune. And that lie got primary traction through Schlabach. And it is a lie. A number of other things. Clune's the one who said that we made the settlement demand, and he hadn't even been hired yet. They have hidden Patricia Carroll. This is a textbook case for the following. For real journalists across this nation to revisit how they cover sexual assault cases. I applaud, agree with, and demand that you continue to not mention the name of an alleged sexual assault victim. You should not and must not. But you also must determine when a woman loses that protection. Is it after a local police department refuses to file charges? Is it after a state attorney's office refuses to file charges? Is it after the woman herself declines for 2 years to bring an administrative proceeding against the accused? Once you decide to cover a sexual assault case and provide this protection, the journalists are deciding to cover half the story. Would not, did not, and acted like they could not mention anything that was exculpatory. Yet, Jameis Winston was entitled to the exact same confidentiality protections as she was. So in all the stories that criticized me, guess whose name was prominent? Jameis Winston. It's indefensible. This guy. Now, so the journalists have gotten to the point where it's right doesn't matter, just being able to cite a source. And this guy exploited the media, and the media essentially became his accomplice in publishing outright lies to put pressure on us. He didn't expect us to appear. The reason he clamored for this proceeding, because he thought there wasn't a chance that we were coming. And we told him outright, we're coming as long as it's fair. We showed up. We had problems with the fairness. They asked to file a brief and were granted the right to file a brief in an ex-parte communication with Florida State that was concealed from us for 17 days. And the public doesn't know about that because they refused to write anything that seems to be pro-accused. It's indefensible. And then you have to talk about the accused right to due process. You have to talk about the institution's conflict of interest when the accuser threatens them with a lawsuit. This case is a textbook of all the things that could go wrong. Yet Jameis Winston stood up to it all, played football on Saturdays, and talks to me on Sundays. This young man and his family are remarkable. It's unbelievable to me that a 20-year-old stood up to this kind of pressure and performed the way that he did. This is the worst attack on an athlete that we have ever seen in the history of amateur sports.
All right. I understand. Obviously, you're an advocate for your client, and you're obviously an excellent advocate for your client, one of the most high-profile attorneys in the country. But if I'm somebody looking at this case from the outside and I'm trying to get my arms around it and I don't have a legal training or a legal background, and I say, what's the one specific fact here that has been the biggest misconception that I would have if I were just watching the media coverage that I should not have? What is the biggest misconception?
You tell me.
You know your client better than I do.
I can't prioritize them, man. I can't give you a list that says there's a single greatest one. There is a list of about. If we get the authority, or if we're challenged, we'll release our brief, and we'll invite the public to read it, and they will see. Do you know that this young lady, after claiming that this man assaulted her, sat there and watched the Clemson game his first year as a starter and tweeted about it?
Fair enough.
About his successful play against Clemson?
Fair enough.
I mean, nobody knows about that because because the media doesn't cover the other side of the story.
Sure, but you understand that. You understand when you have an alleged victim on a woman of sexual assault. Yeah, and you've been clear about that. You've said that they should be protected, and you've been very clear about protecting those rights. And you're just looking for fairness and balance. I get that. All right, last word. I got about 45 seconds left. I will leave it to you. Is there anything that you would like to get out there on your client that you didn't get a chance to with me, and then we'll react to it after that? Go ahead.
It's not about my client. It's about the public, the media relationship with the men who play sports. This is the first case where generally we treat men and women who play professional sports as a different class of Americans, and we accept it because they play for money. I don't agree with it, but it's a fact. This is the first case in our history where we have taken that perspective and moved it into the amateur ranks. And now it's time for a conversation. Now it's time to protect amateur athletes, student athletes, from the kind of vicious attack that we confronted from these attorneys. And there must be something done. There needs to be a public conversation about it from the media, from the public, from the institutions. We can't allow this to ever happen again. This was vicious and unacceptable.
Set it up. You and I will both be on the panel. We'll continue the discussion then and figure out exactly how we're going to fix all this stuff. David, thank you so much for a few minutes this morning. It's been a pleasure hearing your voice.
And I thank you for asking me. Talk to you soon.
Attorney David Cornwell, Jameis Winston's attorney. He's one of the brightest legal minds in the country. I don't know whose side you're on this Jameis thing. I don't know whose side I'm on. But he said 3 things that jumped off the page to me. I will react and tell you what the 3 things you should have got from what he just told you are. That's next. I'm Erik Kuselias, NBC Sports Radio.
This is NBC.